Hi, I'm Jim Bush, a partner at Keystone Law Group, which is a probate firm in Los Angeles. Here are the most important things to know about a partition action. When a real property has multiple co-owners and the owners cannot agree on whether or not to sell the property, a partition action can be brought by any of the co-owners to force its sale. To bring a partition by sale claim, a few conditions must be met. First, the petitioner must be a legal co-owner of the property. Next, one or more co-owners must be seeking to sell their interest in the property, while the other co-owners are refusing. Finally, and importantly, it should be impracticable to physically divide the property among the co-owners in a fair manner. It's typically rare for a property such as a single-family home in an urban area to not meet this condition. While co-owners are entitled to defend partition actions, it's difficult to prevent a partition of property by sale or in kind. This is because the court typically cannot force anyone to maintain ownership of a property they do not want. If a property has been inherited, however, there may be additional grounds to defend a partition action. Defending a partition action by trying to prevent the sale of a property has historically been very difficult to achieve. However, as of January 1, 2022, there is a new law that gives those co-owners who have inherited property they wish to keep hope for a successful outcome. It's important to note that the new law only governs partition actions in which the property is considered heirs property, which means it has indications of family ownership and where one or more of the co-owners acquired their interest in the property from a relative. The new law does not apply when there is an agreement among the co-owners governing the partition of property, even if the property would otherwise qualify as heirs property, which means it has indications of family ownership and where one or more of the co-owners acquired their interest in the property from a relative. The new law does not apply when there is an agreement among co-owners governing the partition of property, even if the property would otherwise qualify as heirs property. As far as the notable reforms made to the law, there are three major ones to go over. First, non-partitioning co-owners must be afforded the opportunity to buy out the co-owner or co-owners seeking partition by sale at a price that represents the value of their fractional interest in the property. Second, the law bolsters the preferences for partition in kind, which consists of dividing property fairly and equitably among co-owners. This way, the co-owners seeking to terminate their interest in the property can do so without forcing the other co-owners to sell. In determining whether to order partition by kind or partition by sale, the court will consider such factors as whether the property has sentimental, cultural, or historic value, whether any of the co-owners would be rendered homeless if the court ordered for the property to be sold, and whether the value of the property would be negatively affected by dividing ownership. Finally, the last major reform made to the law has to do with partitions by sale. In those instances where a partition by sale is the most appropriate remedy, open market sales are not the preferred option. An open market sale consists of a disinterested real estate broker listing the property for at least its value, as determined by the court. The new procedure stands in sharp contrast to the type of auction sales that have traditionally been used for partition sales. This reform was made as a result of evidence showing open market sales yield significantly higher sales prices than auctions. If the co-owners cannot agree on the terms of a deal, they may want to try using mediation to resolve the dispute. Mediation can be used even if a partition action has already been filed. Although, when all avenues have been tried but to no avail, resolving the dispute through a partition action may be the only viable option. What would a successful partition action or settlement look like? There are several possibilities. The first is being bought out of your interest in the property at a fair price. The second is selling the property on the open market using a sales method acceptable to all co-owners. The third is keeping the property but reaching an agreement to rent the property in order to generate income for the co-owners. For the best chance at winning your partition suit, working with an experienced probate attorney is crucial. If you are worried about the cost of bringing a partition action, keep in mind that the court can award all or a portion of the petitioning party's attorney's fees when granting a partition action. In reality, most actions for partition settle prior to trial, so it's important to work with a qualified attorney to ensure that an award of attorney's fees is incorporated into any settlement agreement. This concludes Keystone's video on the most important facts to know about partition actions. If you continue to have questions, schedule a free consultation with our experienced probate attorneys by clicking on the link in the caption. Lastly, be sure to subscribe to our channel to be notified when new content has been posted. Thanks for tuning in.